Good afternoon, everyone. My name is Teresa Wack, and I'm a partner here at Holland & Hart in the Denver office. Welcome to our webinar series. Today's topic is medical records. We're going to talk about a variety of different things related to medical records. So thanks for joining us. I have a lot of slides. Some of them won't take long to go through, but we still have a lot of information to cover, so I'm going to get right into it. As always, we have this is being presented as part of an educational series and to give you general information on these pertinent legal topics, and we try to do the best we can to give you the relevant information that we think is going to help. So the overview of what we're going to talk about today, we're going to talk about the documentation and content of medical records, and kind of included in that, we're going to talk about CMS's regulations and interpretive guidelines for medical records. We'll talk about making revisions, additions, or corrections to medical records, retention, access, and transfer of files, and then security and storage issues. At the beginning of this slide presentation, I've listed a couple of web pages that I've found to be very helpful. There'll be some additional resources at the end of our slide presentation as well, but these are a couple of places that I took things directly out of, and I think you'll find them to be very helpful as well. So as we always do when we start a webinar like this, we want to talk about why this is important, why you should care about medical records. Well, there are several reasons. Proper medical records are critical to a lot of different areas. One, of course, the most important, patient care, the quality of care, the continuity of care between providers. But there are also medical records are important because of legal compliance issues, also in order to get payment and reimbursement from payors. They're important to risk management and medical malpractice type claims. They are important to continued employment and retention of privileges because of employment contracts and the like. Liability insurance carriers want you to have proper records, so they're important for that, and they're important for utilization review and quality of care evaluations. There are potential liabilities associated with not creating and maintaining proper medical records. Those can involve civil lawsuits, malpractice, False Claims Act, lawsuits related to a lack of informed consent or violations of privacy, spoliation of evidence in litigation, or exclusion of key evidence in litigation. So there are some real dangers that make us really need to be careful about medical records. There are also potential criminal penalties for fraudulent claims, improper destruction of records, violation of HIPAA, privacy it carries with it associated criminal penalties. And then, of course, there are administrative sanctions, licensing exclusions from Medicaid or Medicare, civil monetary penalties, and reports to the National Practitioner Database. Last of all, probably of these types of liabilities are the adverse business consequences that can come from not having good medical records and not following the laws related to medical records. There could be reduced or denied payments by payors, loss of hospital or facility privileges for the individual, loss of participation in third-party payment programs, loss of insurance coverage, and loss of reputation. So hopefully we've given you enough information here to know that medical records are important, and it's an important topic for us to delve into. So first we need to know kind of what is a medical record. Well, generically, a medical record is a subset of documents and data that you maintain relevant to a patient. That's a pretty generic definition. But what really is contained in a medical record, or how you define the term medical record, really depends on the context and the reason for it. And so for different reasons or the context of the medical record will determine sort of what is included in that definition. And we're going to talk about several of these subtopics: provision of and payment for medical care, regulatory and statutory requirements, access by patients, and responding to legal process. All of these might have a different kind of definition as to what is contained in a medical record. So let's start with the patient care and operations. Generally, That would need to include documents and data necessary to document the patient's health and health care, of course, provide a means for communicating between practitioners who are caring for the patient. So if there are multiple specialties or multiple doctors at a practice that are caring for a patient, the medical record needs to facilitate that. It provides for a basis for evaluating adequacy and appropriateness of care, supporting claims for reimbursement, protecting legal interests of both the patient and the provider, and providing clinical data for planning, research, and education. So all of these things are how you sort of would define what's needed in a medical record for patient care and operations. The next one that we were going to talk about is regulatory and statutory requirements. I'm going to skip that because that we're going to get to a little bit more later as to kind of what is included in a medical record for those purposes. So let's talk about patient access. What records are, what defines a medical record for patient access? Well, per HIPAA, a patient and a patient's personal representative generally have access to the patient's, quote, designated record set. And this includes the right to inspect or obtain a copy or both. And we must provide the information maintained by a cover entity or one of our business associates on behalf of us, regardless of the date the information was created, whether it's maintained in paper or electronic, whether it's on-site, remote, or archived, and it doesn't matter where the information originated, as long as it is to be included in the designated record set. So I've kind of got these next two slides out of order, so I'm going to skip past the second one and go to this one to determine what the definition of a designated record set is under HIPAA. So it's a group of records maintained by or for a covered entity that are, 1, the medical records and billing records about the individual, 2, the enrollment, payment, claims adjudication, and case or medical management record systems maintained by or for a health plan, and sort of the catch-all, or 3, used in whole or in part by or for the covered entity to make decisions about individuals. That's really sort of the key piece of this. And the record is anything. It's the item collection grouping of information that includes the protected health information and is maintained, collected, used, or disseminated by or for the covered entity. Again, it includes business associates as well. So if it fits this definition of a designated record set, then what has to happen? Well, I'm going to go back to the previous slide. It must provide, if it fits into this designated set of records, then under HIPAA, the covered entity has to provide the information in the form and format requested if it's readily producible in such form. So if it's a request for paper, then it must be in, we must provide it in paper. Even if it's electronic, we have to print it off. If it's a request for electronic copy of paper records, if it's readily producible by our covered entity, then we need to scan and produce it electronically if we can. If it's a request for electronic records, then it should be produced electronically, of course. And we have to provide it in the manner that it's requested. So if they ask it for email or fax or whatever manner, as long as it's fits within our security assessment, risk assessment, if it's not too risky, then we have to provide it. We can't require them that they come to the office. We have to provide it in a timely manner, and we can impose reasonable fees, and I'll talk about that a little bit more in a few minutes. We can only deny access to this designated record set on certain grounds, and they're included in the regulation that I've cited below, but we don't have to provide psychotherapy notes or information compiled in anticipation of investigation, criminal, civil, administrative proceeding, if it was created in the course of research while the research is still in progress, or if it was obtained under a promise of confidentiality and access would reveal the source of that information. Those are things that do not have to be provided. If if access is denied on other bases, then the patient has the right to have the denial reviewed by a licensed healthcare professional designated by the covered entity who wasn't involved in the decision. If the covered entity denies the request, then we still have to give them access to the other information in the file to the extent that we're able to. So, for example, if there are psychotherapy notes in there, we take those out and give them the rest. If we deny the request, we have to provide a written explanation to say what the basis is for the denial, and telling them what their rights are to have an independent review and who they should complain to, et cetera. And if we don't have the information, we have to tell them where it's located. In addition to patient access, so these designated records for patient access, representative of the patient can also receive those. That's an individual who has the right to direct the covered entity to submit the information. So the individual who is the patient says, I want you to provide this information to my representative. The request has to be in writing, it has to be signed by the patient, and it has to identify the designated person and where to send it. I just see and I don't know if Luke, if you're listening in, but I just got an email from our receptionist saying that there are people calling the main line saying that they can't see or hear or join the webinar. So I don't know if that's something that can be fixed or not. I'm going to go on, but just wanted to let everyone know that. The representative, again, can get the information just as the individual can, so long as the individual allows for it. It's the same requirements of being able to deny, just like for the patient, if the circumstances provide that. For one other thing to talk about with respect to patient access for medical records, a covered entity must document the following and retain this information as required by the site that I've provided here. And you have to document that the designated record sets that are subject to access and the title of the person or offices responsible for receiving and processing requests. Now, it's important to talk about, when we talk about patient access, that was all under HIPAA. So there might be state laws that also deal with access to medical records. If the state laws provide greater rights to the patient, then the privacy rule does not preempt them. So, for example, if the state law requires a shorter time frame for production, then you have to comply with the state law. It's only if there's a conflict that HIPAA provides more rights to the person, then you have to follow HIPAA. And so, as an example of when HIPAA provides more access is, for example, some state laws say that they prohibit certain laboratories from disclosing test results directly to the individual, but HIPAA allows for that, and so the state laws don't apply when HIPAA provides more access. While we're talking about access to medical records, HIPAA also allows for the sharing of information with other practitioners for the purpose of treatment, payment, and some healthcare operations. It doesn't require an authorization, and the minimum necessary I'm getting another note. Yeah, Luke's working on it for those of you listening. So just so that you know, we're trying to figure out what's going on. Okay, going back to the presentation, sorry. So this is about other practitioners. I'm sorry, I lost my train of thought. So the next area when we're talking about medical records and what is defined, what is included in the definition of medical records, the next thing we need to look at is what if it's a subpoena? And there's really no legal definition of medical records for purposes of the subpoena. Really, you just have to, you're bound by the terms of what the subpoena is asking for, regardless of the internal definition that the covered entity might have. So if they ask for it, you have to provide it unless the covered entity files an objection through legal counsel or obtains a waiver. However, if they don't ask for it, you don't have to produce it. The trick is if the request is broad and it says all medical records of the patient, then you have to turn over all records regardless of who created it. So you might have gotten records that are from other providers that are in the medical record, and if it's asking for all medical records, you have to provide it. You can ask for clarifications through the attorney who's subpoenaing them, and it may help to adopt a policy sort of defining medical records, but it's not a fail-safe solution. You really have to follow what the court is mandating. So overall, really, each organization needs to establish its own medical record policies after considering all of the things kind of we've talked about: clinical needs, business needs, legal needs, statutes, accreditation standards, third-party payer requirements, standards of care, practice concerns regarding space, time, duplication. So the covered entity should come up with its definition of medical record. Here's a slide that just shows sort of generally what types of things are included, and I'm not going to go over all of those. You'll have those in your slides. But generally, medical records do not include these items: psychotherapy notes, administrative documents, the actual payment being received, and so on, quality assurance, peer review, those types of things. Those are not included in the definition of a medical record generally. When you are trying to determine what is in a medical record, don't forget to consider sort of the things that might not come to mind initially. For example, electronic health records, and I think that's really important nowadays because we have paper records and we have electronic health records, and making sure that you kind of cover all of the bases. Emails that might be exchanged between the doctor and the patient, images, x-rays, those kinds of things, data captured by machines, data stored in different systems, labs, cardiology, for example, audio or video files. Those are things that you just need to think about that they are a part of the medical records as well. I've provided a list of things that come from the condition of participation for Medicare, Medicaid. This regulatory provision provides a laundry list of things that sort of should be what are clinical records, and here's the list of things that are included in that regulation. Some things to consider as you're kind of determining about what's included in a medical record. What about records received from other providers? Now, we know under the designated record set and what the definition of that is, that if it's being relied on to provide care, then it needs to be included. But what if it's not being relied on to provide care? So that's something to consider in your policy. Personal health records that were created or provided by the patient. Maybe it's a narrative from the patient. Is that something that should be included in a medical record? Working notes, emails, text messages, those kinds of things. Yes, they probably should be included. Duplicates of documents, but be careful about duplicates with additional notations because it might be the same document, but it has additional notations. So these are all things to consider when you're putting together any sort of a policy regarding medical records. I just wanted to touch on this for a minute about transitioning from paper to electronic medical records and what's included, because I think that's a really hot topic right now because of where we are in technology. We still have paper records, but we're also transitioning to electronic health records. The important thing is that you have to ensure that patient care and appropriate record-keeping practices continue without interruption. So what do you need to put in place to make sure that all of the records can be accessed? If you're converting paper into an electronic format, for example, scanning it, you have to ensure the integrity of the data. You should establish specific procedures for converting files and document those procedures in writing. You need a quality assurance kind of aspect to this to verify that the documents have been properly scanned. There's not pages missing or jammed somehow. You should ensure that the entire record is intact, including all attached notes and handwritten comments. And you should consider retaining paper charts at least for some period of time to be able to check on things if there turns out to be mistakes. So I think we're still having some problems. I'm continuing to get emails about that, so hopefully we're still looking into that. But Okay, so we've talked sort of generally about medical records and what they are and how you define them and access to them, et cetera. So now I want to talk about more like specifics of the content of what they should contain. So obviously we should provide a record for every individual that's assessed or treated. One sort of questionable area has to be if there might not be a medical record because of the circumstances, but one probably should be created under these circumstances. For example, patients who call but don't show up for appointments, should there be a medical record created for that just to document what happened in case there's a problem later? Patients who leave against medical advice, patient phone calls and emails, consultations between providers, the consultations where the other physician has the record, but the person that's providing the consultation, they should probably create a record as well and make sure that it gets in the file so that there's a documentation of what's happened. The record should contain sufficient information to identify the patient, including the name and health record number on every page. They should be sufficient to support the diagnosis, to justify the treatment, to document the course and the results of treatment, and promote continuity of care among providers. That comes directly from 42 CFR 482.24. There may be other things, but these are sort of just the general justification of what needs to be in a medical record. Here's a laundry list also from that same regulation of kind of what should be included. Informed consent for treatment. I think that's an important one to talk about because it's not always enough just to have the form that the client or the patient signed in there. The doctor really should prepare a note and put a note in the file as well about the informed consent and what was provided so that there can't be any question later, including who was present when the informed consent was obtained. The other things are pretty self-explanatory: history of present complaint and relevant past history, examination and inventory of systems, provisional diagnosis, observation, progress notes, diagnostic test results, orders, patient status, treatment, communications. All of these are things that should be included in the actual medical record. And I put this slide in here right now sort of as a public service reminder. We're going to talk more about the content, but remember the general premise is if it's not in the chart, it didn't happen. And if the chart can't be found, it's because you're hiding something. That's the way things are going to be looked at. So they're really, really important. Medical records are often the most important objective evidence that we have in our defense against legal claims. And aside from legal considerations, also it's the most important reason is to maintain accurate, credible, the most important reason to maintain accurate and credible records is that it protects the patient. So just remember that as you're thinking about what kind of things should be in there. Here are some specifics, sort of cautionary things that I think are best practices with respect to drug allergy information. Make sure that it's prominent and it's consistent on every file wherever it's at. If it's a paper file, maybe a brightly colored sticker on the cover of the chart. It needs to be periodically updated, and you might consider using a medication control record. That's just a hot area where there can be lots of claims, and so it's extremely important. For patients with the same name, for example, maybe a father and son have the same name, include some sort of notice or warning about that. Place documents in reverse chronological order with the most recent on top. Make sure it's a very systematic way that you do this. And think about having tabs and dividers and sections of medical records that are cumbersome or large. It's also some more cautionary things. Make sure that all papers are attached to the file. You don't want free-floating papers in there. And this is probably more relevant when we were doing more paper records as opposed to electronic, but it's still, we still do create paper records, so it's still important. No Post-it notes or stickies. And if you have a Post-it note or sticky in there, staple it to a piece of paper. It's important to document that patient education that was given and instructions, missed appointments, canceled appointments, noncompliance. Those are all things that are very, you might think that they're just there for defensive purposes, but really it's important for a continuity of care so that the next provider or another treater will have information about this patient, because those things really are important. Document returned visit advice, referral notes, disruptive conduct. Now, if there are patient complaints, you may want to put those into a separate file and not actually in the medical records file. Some other things to think about for the content. Document phone calls in the chart. Documenting them in a separate log is risky. It may never make it into the chart. So it's important to develop a procedure with your office staff about phone calls. Same thing about emails, about how they're going to get printed and put into the chart or electronically transferred to the chart. You might consider putting a problem list in group practice charts so that you're identifying in one place certain serious medical conditions, so that each time that patient comes back, if they're seen by a different provider, that they, instead of having to review the progress notes, they'll see it right there about these serious medical conditions, and then they'll know to go back and look at notes. The important caution on that is that that list has to be current and complete so that it doesn't mislead other providers that are looking at the chart. And then one last sort of cautionary thing or thing to think about is that you might red flag medical problems that are not resolved so they can be followed up on the next visit. Now let's talk about entries. Who makes entries into the medical records? Really, the practice or the provider has to determine who's going to make those entries. There's generally no law governing who's authorized to make entries. HIPAA requires that providers, covered entities, establish policies, identifying those who have access to make entries into medical records. The only sort of cautionary thing I would say about who can make entries is that CMS, when they're looking at this meaningful use objectives under that program, they specify that orders can only be entered by a licensed healthcare provider or a medical staff person who is a credentialed medical assistant. So otherwise, that there aren't the other meaningful use objectives do not specify. It's just that with respect to orders. Direct treatment providers should make entries into the medical records documenting their care, so that's physicians, independent practitioners, nurses, others. It's not limited to licensed practitioners. Anybody who is providing treatment should make the entries. The provider or the covered entity should train personnel concerning proper entries, the form, the content, the method, the timing. Each entry, according to 42 CFR 482.24, it should be legible, it should be complete, dated, timed, authenticated, either in written or electronic form. Written, if you're doing a paper chart, written in ink or typed so that it can really be permanent and legible. They need to be specific. The entries should be objective, based on facts, not speculation. If you're quoting the patient, you should use quotation marks so that we know when we're looking at it later that that's what the patient said, and you should use standard approved abbreviations and symbols. The CMS manual gives some interpretive guidelines to give further guidance on that particular regulation, and specifically they say that a medical record is considered complete if it contains sufficient information to identify the patient, support the diagnosis, justify the care, treatment and service, document the course and results of care, treatment and services, and promote continuity of care. So that's their interpretive guideline about what they consider complete. In this guideline, though, they also talk about the importance of dating and timing entries, because it's necessary for patient safety. It establishes a baseline for future actions. It establishes a timeline of events. They say that you must have a method to establish the identity of the author of each entry, and they have to be able to authenticate that the person who makes the entry, it has to be authenticated. So They have to verify that it's his or her entry, that she's responsible for the entry, and that the entry is accurate. Authentication can include written signatures, initials, computer keys, or other codes, but there does need to be a procedure for authentication. When the guideline also says that when rubber stamps or electronic authorizations are used, the hospital has to have policies and procedures to ensure that those stamps or electronic authorizations are used only by the individual whose signature it represents. You can't delegate that to someone else. But beware, because insurers and payers may have policies prohibiting use of rubber stamps, so just beware of that. For electronic medical records, the guidance talks about how you have to demonstrate how the system prevents alteration of record entries after they've been authenticated. There must be a method of determining that the practitioner authenticated it after it was created. The practitioner must separately date and time his or her signature. Even though there might already be a date or time on the document, the signature needs to be date and time stamped, so to speak, as well. And it talks about that if there are state law requirements regarding countersignatures of supervisory staff, then that should also be included in the policy. So sort of to summarize the kind of 4 key points about the content of medical records, these are the 4 key things. 1, they have to be accurate, because it's being relied on by other people. Don't make entries for others, and if additions or corrections are necessary, make sure they're done correctly. Second point is that it needs to be complete. Don't leave blanks, gaps in the chart. Don't leave spaces. Don't start a new form until lines on the prior form are filled in or crossed out so that there can't be alterations, and complete all fields. Third key point is relevance. Don't use the record to speculate, to gripe, to complain, or blame others. Avoid criticism of other professionals and chart notes, and avoid unsubstantiated subjective type remarks. Keep everything factual and objective. And then the 4th key point is timeliness. The entry should be made contemporaneously or as soon as possible. Laws or regulations, policies require completion of records within a certain time, so beware of that. The more time that passes, the less reliable it is. That's just common sense, and from an attorney's standpoint, it's really important for us that you do it as soon as possible. Never make entries in advance, and never backdate entries. Those seem to be pretty common sense, but should be mentioned anyway. Okay, so now let's talk about what if there are errors? What if there's an error in the medical record? How do we fix that? Can we fix that? Late entries, corrections, and amendments are okay so long as they are designated as such. So, and we'll talk about how to do that in just a minute. No one's perfect, not even physicians, and so it's important that the record is accurate, even if that has to be done at a later date. So, errors and amendments should be done in a manner that preserves the original entry. We don't want to obliterate or remove the original entry. Instead, if it's a paper record, draw a single line through the error and designate it as error. The amendment should be initialed with the date, time, title, and the reason for the change. If the original document was in paper and then scanned, as we talked about earlier, then you need to reprint the original document, fix it, and rescan it. Electronic documents should be corrected with an addendum labeled as an addendum with the date, the time, the title, the reason for the change, just like you would in a paper copy. Again, I can't emphasize this enough, never erase, obliterate, or delete prior entries. From a legal standpoint, as a lawyer defending you, there's an inference of bad conduct, and there's a potential claim for spoliation of evidence, tampering with evidence, obstruction of investigation, etc. So correcting electronic documents follows the same basic principles. The system has to have the ability to track corrections or changes once it's been entered or authenticated, and the original entry must remain viewable. When an entry was missed or not written in a timely manner, then put the entry in and identify it as a late entry. Enter the current date and time, not the date that it should have been done, but the current date and time, and do that as soon as possible. The longer the time lapse, the less reliable the entry becomes. So it's better, again, to put it in there late than never, but as soon as you can is better. So this came up recently in a discussion, and we thought it would be helpful to put this slide in here. How do you handle an incomplete record when a provider has left the practice or the facility? You determine later that the record is not complete. Well, some options are sending a letter to the provider, informing them of their obligation. There's probably something in the employment contract about the medical records and what their obligations are towards their patient. You can warn them, sort of up the ante, and warn them that there may be some consequences if they don't complete the records by a certain date. Again, at a higher level, you can report it to the state licensing board, as that is a violation of their duty of care. And ultimately, you may end up having to file some sort of a lawsuit forcing them to complete the records. So those are some unfortunate options that you may have to take if somebody has left the practice. Kind of as a summary for the provider or the covered entity making changes and additions to the records, here are just a few items. Never amend or correct a medical record after receipt of notice of a potential claim, because that is going to look like you're doing it to try to cover something up. Obtain a legal advice in that instance if the errors are discovered after the complication or after a claim is threatened. Talk to a lawyer about how to address that situation, because deliberate alteration of medical records is illegal and it's unethical, and it carries penalties. And never forget that technology is sophisticated. There are footprints left, and so changes to records can be seen. And so that was all talking about if we want to, as the provider, the covered entity, to correct the record. Patients also have a right to request an amendment to records in their designated record set. We can request that that be done in writing, and we can require an explanation for the request. And we have to act in a timely fashion when we get the request. We have to respond within 60 days about whether that we're going to change the record or not. And these regulations are found in 45 CFR 164.5.526. If the provider accepts the amendment, the patient requests it in writing, and we realize that, yes, we needed to make that amendment, then we need to make the amendment to the record. We need to attach or link the requested amendment to the relevant records so that it's there with the other record that needed to be changed. We need to notify the individual of the amendment, and we need to seek permission to notify others regarding the change. Who else would need to know that this record was amended? The patient might identify some persons, or maybe persons who rely on the prior record to the detriment of the patient, so other doctors or business associates. Now, if we refuse to make the amendment, we can only do that under certain circumstances. And again, the regulation is cited there, but we can refuse to make the amendment if we're not the provider that created the record, unless the person who created the record is no longer available, so it's going to go unamended, and maybe there's an error left in there still if the person is no longer available. We can refuse to make the amendment if it's outside the designated record set, or if the record is not subject to patient access, like the psychotherapy notes, et cetera. Or if we think that the record is accurate and complete, we can refuse to make the amendment. If we deny the amendment, however, there are some things that we must do. One, the denial must be in writing, and we have to explain the basis for the denial, and explain also to the patient that they have a right to attach a copy of the request to their record. And we have to explain complaint procedures. Again, the denial must be timely. We talked about that already. We can also provide, so we do have to attach a copy of the request or statement in the record, but we can provide a rebuttal statement as well and attach that into the record. The provider must provide the request or statement with any future disclosure. So even if we don't change or amend the record, we have to provide the request that the patient asked us to change it. So this is sort of a summary of additional things that, as providers, we must do when it comes to additions or corrections. One, if we're informed that there was amendment from another covered entity, then we need to change our records to match that. We also have to document the names and titles of persons responsible for receiving and processing requests for amendment, and we have to retain the documentation as required by 45 CFR 164.530 subsection J. All right, now let's move on to control and access. Who has control over the records and who has access to them? First thing to think about is who owns the medical records. The provider, the practice, the facility owns the records. It's not the patient and it's not other providers. It's the people who created the records. In case of an institutional provider or practice, the organizing documents like the contracts, bylaws, those kinds of things should specify who owns the records. They need to specify who gets the records upon termination or dissolution, and they need to give practitioners reasonable access during or after termination of practice to defend themselves if there's something that comes up. So the owner of the records may generally deny access unless the law provides otherwise, and we've already talked about previously about under HIPAA how a patient and a patient representative has access to the designated record set. Medicare, Medicaid, conditions of participation may grant access, subpoenas, et cetera. So we can deny it unless a law provides otherwise. We can also charge a reasonable fee for providing access for that. And regarding access controls, so that's who owns it, has access. HIPAA requires that we have reasonable administrative, physical, and technical safeguards in place to protect the access, so secure rooms, computers, monitor, control access, log for after-hours entries, and not allowing originals to leave the facility. So we've talked about ownership and access. Let's talk a little bit about retrieval and charges. We've touched on it a little bit before, but the owner, the providers, should have a process that allows for prompt retrieval of relevant information. It needs to be done timely, as we talked about before, so there needs to be a mechanism in place for that to happen promptly. HIPAA does allow for you to charge patients and a personal rep a reasonable cost-based fee. So it's the cost of supplies and labor to copy, not labor of retrieving, but labor of copying. Cost of postage if it's done by mail, cost of preparing an explanation or summary if that's what the patient requests. But you can't charge for retrieval, handling, or processing of the request. The HIPAA limits on charges only apply to patients and patient representatives. They don't apply to other practitioners, lawyers, response to subpoena, insurers. You can charge fees for that. They don't have necessarily the same limits as the fees under HIPAA. Nevertheless, state laws or regs may limit your fees, so you need to be aware of what your state laws are regarding copying charges, et cetera, and payer contracts from the insurance companies may limit the charges as well. So here are some suggestions about sort of the retrieval and charge process. We suggest that you establish policies and schedules as to how you're going to charge patients. Again, that needs to comply with HIPAA. For others, practitioners, payers, put a policy in place and notify the patients and others in advance of the charge. Notify them at the time of the request. You can negotiate charges in your payer contracts, and you can also generally require payment before production. You can't, however, withhold the production if this is not in the slide, but just as a point, if the client or the patient is behind on their bills, if they pay for the production, you can't withhold the production until they pay their bill for the services that had medical services rendered. All right, now let's talk about medical records and retention, sort of where do they go? So you need to establish a written retention and destruction policy. Why? Because one, it facilitates patient care. It's necessary to comply with statutes, regs, contracts, accreditation standards. OIG recommends a proper record retention policy. HIPAA Security rules require it for electronic health information, and you need it to establish a defense against claims or allegations of improper destruction of records. So if you have a policy in place as to why you do it, and it's not just randomly, but it's done under a policy, then that is helps in defense. So at a minimum, the retention policy must ensure that the patient health information is available to meet the needs of continued patient care, legal requirements, research, education, other legitimate uses. It should include guidelines that specify what information is kept, for how long, how it's going to be stored, like what medium, is it going to be on DVD, what kind of the medium for storage, and the location, is it off-site, on-site. The policy should include clear destruction policies and procedures that include appropriate methods of destruction. We're going to talk about what those appropriate methods are in just a minute. It should designate a person to be responsible for deciding what to keep and destroy. It should make sure that there's a log that records what's been destroyed, and the policy should also provide for employee training. When you're establishing the record retention policy, it's important to consult the medical staff, obviously, to see what needs they have for patient care. Consult with attorneys, risk managers, even your liability insurance carrier about what they need and how long records should be retained under their coverage, and administrators, medical records director, those types of individuals. There is no single standardized record retention schedule that organizations or providers have to follow. It really is very dependent on patient needs, on regulatory and statutory requirements. There are lots of different time frames. Medicare, Medicaid, for example, says 5 years for hospitals and 6 years for critical access hospitals. HIPAA privacy regulations require 6 years from the date of creation or the date when it was last in effect, whichever is later. Some accreditation standards might require certain lengths of time, contract terms, insurance, again, you need to look at that, and risk management concerns. There might be some state medical board policies. For example, here in Colorado, we have a policy that recommends 7 years, keeping records for 7 years for adults, and for minors or folks who were minors when they had the treatment, 7 years past the age of their majority. So these are all things to consider. In the absence of specific state requirements, you should keep health records for at least the period specified by the statute of limitations. And each state's statute of limitations are a little bit different, but generally for malpractice, it's generally 2 years. But again, you should check your state statutes. That time might be extended, however, if it's a foreign object left in the body or the malpractice was concealed somehow. So it's 2 years from the time of discovery. It can also be told for minority individuals under the age of 18. Many states, most states, toll that statute of limitations until they reach the age of majority, and then it's a certain number of years past that. The relevant statutes for statute of limitations for breach of contract is much longer than malpractice, and most states have difference between written and oral contracts. But the important thing about this is keeping the records for as long as you need to defend against some problem in the future. Relevant statutes of limitations if Medicare or Medicaid are involved. Here's a couple things. Under False Claim Act, it's later of 6 years from the date of violation or 3 years after the government have notice, but no later than 10 years from the date of violation, but that's still a long period of time. Civil monetary period, 6 years from the date the claim was presented. So those are all things that you would consider when you're developing your policy. The Association of Health Information recommends a minimum of 10 years. Defense attorneys, speaking as an attorney myself, recommend that retain them forever. It's hard to defend a claim without records, and I know that that's difficult to do because of volume, but with electronic means nowadays, it's much easier to retain them than when it was in the paper form. A study completed in 2008 by the Association of Health Information found that many hospitals do keep records permanently, and then the next most frequent standard was 20 years. Miscellaneous things to remember about retention. Retention or destruction policies should be suspended immediately for any records that are relevant to threatened or pending investigations or litigations. And if you're using an outside entity to assist with record retention or destruction, you must have a HIPAA-compliant business associate agreement in place. So this is a little bit off topic, but because it's not medical records, it's about credentialing files. But this also came up recently in some discussions that I was involved in, and I thought it might be helpful to talk about keeping credentialing records as well. Again, it's best to keep them forever if possible, but if you can't keep them forever, keep them for at least 5 years after the retirement of the provider or death if the physician is practicing at the time of death. Keep them for 5 years past that. Even then, there could still be issues, and that's especially true with obstetricians because the the statute of limitations for minors is so much longer. Keeping the records forever protects against negligent credentialing claims. It's hard to defend a claim for negligent credentialing without the file. And for physicians, I think they find it's beneficial for hospitals to keep them because some licensing authorities want credentialing documents for all hospitals at which the physician has ever been credentialed. So think about, is there a way to scan and store these electronically so that you could keep them longer? Here are a couple of screenshots from some appendices to publication by the American Health Information Management Association. I just think they were really good publications and things for you to look at, so I've included 2 slides in there regarding some standards and timelines for retention. Storage. We only have a few minutes left, and I have several slides, so I'm going to kind of go through these fast, but you have to keep records stored in a safe and secure environment to ensure the physical integrity of the documents, to safeguard against improper access, tampering, defacement, to ensure the confidentiality. So they have to be safe and secure, but they also have to be readily available and producible. You need to take reasonable steps to ensure protection from theft, loss, and unauthorized use or disclosure. Keep them paper records in a restricted access area or a locked filing cabinet. And don't allow the record to be removed from the facility without a subpoena or court order for the original. You should think about moving off to off-site storage after a reasonable time. Use a sign-out system when the record is being removed from storage. Establish a system to allow proper retrieval, and implement administrative, physical, and technical safeguards. This is under the security rule, and I've got a few slides in here on the security rule. We've had presentations about this before, so I don't want to belabor this too long, but I think it's helpful to have these in the slide presentation today because it does give you the site for the CFR site and gives you some examples of what you need to do to safeguard. Now, know that this applies only to electronic health records, but that I think is becoming obviously more the norm these days. So the security rule provides there are some things that have to be implemented in the rule, and there are some things that have to be addressed. So if you have to look at the reasonableness of it, and if it's not reasonable, you have to document why it's not reasonable. So there are a few slides in here for that. I'm going to jump ahead just to talk about the 3 different areas of the security rule. The administrative safeguards, here's a list of bullet points for electronic medical records and what needs to be, what's required under the security rule for administrative safeguards. For example, having a security officer, evaluating your security measures, training, having a process for training your members, et cetera. So those are administrative type things that are necessary under the security rule. Here are physical safeguards that are necessary under the security rule. You have to limit access to the devices and physical facilities that contain the electronic records, secure the workstations, create backup copies, implement policies for disposal, et cetera. And then the the last slide under the security rule is the technical safeguards. And again, I won't go through all of those, but they're here for you to look at. And we do have on our webpage some previous webinars where we've gone over these in much more detail. The last point on security rule is documentation. It's important to document everything that you do regarding the security rule and how you're protecting the electronic health information. And you're required to maintain that information for 6 years and to review and update it frequently. All right, now let's talk about destruction. Destruction has to be carried out in accordance with federal and state laws. You should not ever destroy records that are involved in any kind of an investigation, audit, or litigation until it's closed. As with the record retention, there's really no single standard about destruction. It could vary depending on state laws. It could vary depending on federal laws, those kinds of things. But unless the state law is to the contrary, organizations must ensure that records are destroyed with a method that provides no possibility of reconstructing the information. So when you do go to destroy them, you have to destroy them in ways that they cannot be reconstructed. And here's a list of ways that the American Health Information Management System recommends for destruction. And it's important, like for computerized documents, to make sure that there's not a shadow copy somewhere. You really do need, when you're destroying the records, you need to make sure that they are destroyed. You must maintain documentation of the destruction of health records permanently. So you have to document how you're destroying them, when you've destroyed them, what you've destroyed, statements that the records were destroyed in the normal course of business under the policy, signatures of individuals supervising and witnessing the destruction. So it's all very important that you document all of that when records are destroyed. Ethical statements sometimes require that notice be given to the patient before you destroy the records, but generally there's not a legal requirement to do that. There are some exceptions. For example, if the records are being destroyed because a company is going through bankruptcy and they can't maintain them, then you do have to give the patient notification that you're going to destroy them. Under the HIPAA privacy rule, if the destruction services are outsourced to a business associate, then there needs to be a business associate agreement, and the business associate agreement needs to establish the permitted and required uses and disclosures. They have to include the following elements: the method, the time, safeguards, indemnification for the organization, or provide for loss due to unauthorized disclosures. So all of these things should be included in the business associate agreement if you're using an outside source to destroy documents. All right, the last couple topics are sort of transferring records and ending a physician's practice. A physician selling a practice may designate the purchaser as the custodian of records, but you can't sell the records to that new practice, and you can't transfer the patients to the purchasing physician's practice, but they can be the custodian of records, hold the records for the patient. So the patient has to have the right to select any physician they choose. So the purchase contract, if there is a sale of a business, should specify that the buyer will be the custodian of records, that the records will be maintained in a safe place, that the records will be available for transfer to a new physician if that's what the patient wants, and that the records will be held for a certain number of years and that there won't be destruction within that time without consent of the seller. End of practice. So what if a physician or a practice is closing down? If the physician is terminating the practice or retiring, or physician group is shutting down a practice group, then they're responsible for making the appropriate arrangements for disposition of records when the practice closes. Physicians turning the practice over to a replacement physician should have an agreement. We talked about that. When a practice closes and medical records are transferred, the patient should be notified that they may designate a different physician or another provider to receive their records. And they should also be notified that if they don't designate a physician, that the records may be transferred to a custodian for holding. So I've taken us all the way up to the end. I wanted to give you some additional resources, though. These are some of the regs that I've cited in this that are really relevant to the medical records and what needs to be contained. But probably the best resource, I think, is the American Health Information Management Association, and I've put their web address there. They have great resources on there about health information management, so I'd encourage you to take a look at that. Additionally, we have on our website publications that hit on some of these things, and you can search for those. We again have these monthly webinar series that I think you all know about, and those can be found on our webpage. There's the address there. And we try to update, provide client alerts, et cetera. And if you're not on our client alert list, I would just encourage you to shoot me an email after this, and we can get you on that list. So thank you for your time today. I really appreciate it. And I'm sorry about the technical difficulties we haven't had with this, but I hope it's been a benefit to you. I do see that there has been one question, and so I'm going to figure out a way to respond to that question by email. So thank you all for your time, and I'll talk to you next time. Thanks.